Welcome to this short presentation on redundancy consultation. I'm Andy Pearson and I'll be your host for this session. So what are the aims and objectives of this session? Well, it's to provide training, information, advice and guidance on the redundancy consultation process and what it all means. We will look at what is redundancy, what is consultation, what are your duties and responsibilities and your role within the process, what support is available, selection pools, selection criteria and discrimination, notice pay, redundancy pay, time off to look for work, alternative employment and trial periods. So let's get started. Redundancy. What is it and what does it mean? Opposite you will see the statutory definition of redundancy as it's laid out by the Employment Relations Act of 1996. This definition can be found in section 139 and it's quite wordy, but what does it really mean? Basically, you are made redundant if your employer ceases or intends to cease either to carry out the business for which you're employed or to carry out that work in the place for which you're employed. The second requirement could be that the business has been reduced, so there is no longer the work needed for you or at your site. Under these circumstances, a dismissal could be classed as a redundancy. Let's take a look now at consultation. Employers are required to consult collectively over redundancies. This requirement is set out in section 188 of the Trade Union and Labour Relations Act of 1992. Where there are 20 or more employees at an establishment, the employer is required to consult. They can do this with the recognised trade union. If there is no recognised trade union, they must consult with elected employee representatives, or, in a last resort, with individual employees, one by one. Proper consultation begins with the disclosure of specific information in writing to the appropriate representatives or to employees, and this is required by Section 188 of the Trade Union Labour Relations Act. The information to be disclosed is as follows: the reason for the redundancy proposals, the number and description of the employees who it is proposed to dismiss as redundant, the total number of employees of any such descriptions employed by the employer at the establishment in question. This is a clear distinction. You don't make people redundant, you make roles redundant. Therefore, anybody with a similar role should be included in the pool. The proposed method of selecting the employees who may be dismissed, the proposed method of carrying out the dismissals with due regard to any agreed procedure, including the period over which the dismissals are to take effect, the proposed method of calculating redundancy payments to individual employees. If this differs from the statutory scheme, it may be that in the past you've negotiated or your trade union has negotiated better terms and conditions for those being made redundant. So what will the consultation look like? Well, section 188 outlines that the consultation must include ways to avoid dismissals, reducing the number of employees to be dismissed and mitigating the consequences of the dismissals. Consultation must be undertaken by the employer with a view to reaching an agreement with the appropriate representatives or employees. The consultation process must be expected to cover issues such as reallocation of work, the retraining and redeployment of employees, meeting with outside support agencies, and information on training and retraining opportunities elsewhere. Fair consultations allows for consultation to begin when the proposals are still at a formative stage, adequate information on which to respond, adequate time in which to respond, conscientious consideration by the employer of the response to consultation. It is a two-way process. It's not the employer enforcing their will. It should be a consultation. So what's your role in the redundancy process? As an elected representative, your role is to work for the best interests of your members and keep members informed of any developments. In addition to collective consultation, People at risk of redundancy have a right to be consulted individually. Union reps can accompany individuals in meetings with managers to ensure a fair process is followed. It is also your responsibility to ensure all alternatives to redundancy, including redeployment or retraining, are explored. If you are ever unsure of any part of the process or what is being discussed, remember you can always ask for an adjournment and seek advice from your regional officer. You won't be going through redundancies alone. Your officer is there to support you. As an elected representative, you have the support of your regional officer, Unite's legal team, and the Learn with Unite team to ensure that you have all the relevant information and training you need to support your members through this difficult time. As well as the support from the union, you are also entitled to paid time off, facilities, and statutory protections throughout the redundancy process. Let's have a look at paid time off for reps. Reps are entitled to reasonable paid time off for the consultation over collective redundancies. Union reps are also entitled to reasonable paid time off for certified training in their role. So if you haven't had training on redundancies, speak to your district office as soon as possible, as we can set this up for you. Where there is a recognised trade union, this right is found in section 168 of the Trade Union Labour Relations Act. Time off is paid at the appropriate hourly rate. There should be paid time off for pre-meetings and side meetings of representatives to determine policy, meetings with affected employees to canvass opinion, training in the law and industrial relations practice on redundancies, and information and consultation. Also, meetings with the employer should be covered by paid time off. For such accommodation and other facilities as may be appropriate. Negotiated facilities for reps to undertake their duties is very important and can include the following: access to means of communication such as telephones, email, intranet and internet. It's also useful to have a printer. Accommodation for meetings and pre-meetings. You may not have a union office, but you should be given access to other office facilities. Dedicated office space. In many cases, this can just mean a filing cabinet, but if you are lucky enough to have dedicated office space, you're on a winner. And as we've said before, you are entitled to access to training. So let's look now at what we mean by statutory protections for representatives. Reps are protected against unfair dismissal or any detriment connected with their representative role. Protection against detrimental treatment is guaranteed under Section 146 of the Trade Union Labour Relations Act. This is in effect for trade union reps in recognised workplaces, and under Section 47 of the Employment Relations Act 1996 for all other appropriate representatives. Dismissal, wholly or partly, for acting or standing as a rep is automatically unfair. There is no qualifying service required. Let's look at selection for redundancy. The criteria used by an employer to select employees for redundancy must be both fair and reasonable. In many workplaces across the Union, there is an agreed procedure in place for selecting those for redundancy. A redundancy procedure will rarely be contractual, even if it has been collectively negotiated. This means that changing it will rarely be a breach of contract. In contrast, a promise to pay enhanced redundancy payments is much more likely to be contractual. As far as possible, an employer should seek to establish criteria for selection which do not depend solely upon the opinion of the person making the selection, but can be objectively checked against criteria such as skills, knowledge and experience. It should also include any technical skills that may be in short supply within the company. There are some basic guidelines laid down for a fair redundancy dismissal, and these include giving as much warning as possible of likely redundancies, consulting reps on the best way of causing as little hardship as possible to employees, draw up an agreed criteria for selection, ensure the selection criteria are capable of objective verification. Carry out the selection exercise fairly, following the agreed criteria. Consider alternative employment. Consult with employees on issues affecting them as individuals. Allowing employees the opportunity to appeal against the decision to select them for redundancy. Let's now look at discrimination. If the selection criteria and/or the selection process discriminates on the grounds of sex, race, disability, age, sexual orientation, transgender, religion or belief, marriage or civil partnerships, pregnancy or maternity, or in Northern Ireland political opinion, the employer's actions can be challenged under the Equality Act of 2010 or equivalent legislation in Northern Ireland, as well as under unfair dismissal law. Many commonly used selection criteria carry a risk of discrimination. These can include attendance, sickness absence. For example, failing to exclude pregnancy or disability-related absences is seen as discriminatory. Timekeeping, flexibility, or language requirements. These are all deemed discriminatory criteria in some way. So what constitutes automatically unfair criteria? Some selection criteria are deemed as automatically unfair, and this is covered in Section 105 of the Employment Relations Act of 1996. If the reason, or if more than one, the main reason for redundancy selection is one of the following, the employer is not allowed to argue that its decision was reasonable. No qualifying service is needed for a claim based on one of these reasons. A union-related reason, including recognition. Participating in official industrial action. A reason related to a prohibited list. This is often related to as blacklisting. Selection of a woman for a reason related to pregnancy or childbirth. Leaving or refusing to return to the workplace in circumstances of danger which the employee reasonably believed to be serious and imminent and could not avert. Asserting certain statutory rights, for example the rights under the working time regulation. It's also deemed automatically unfair if you assert your rights under the national minimum wage regulations. Making a protected disclosure, often called whistleblowing. Asserting a right protected by the Part-Time Workers Regulations 2000. Asserting a right protected by the Fixed-Term Employees Regulations of 2002. Asserting a right to request flexible working. Asserting a right to request time off to study or train. And taking or requesting leave for family reasons. We can also add to that list standing or acting as a rep in a variety of circumstances, either as a rep for collective redundancy or TUPE purposes, under the information and consultation of employee regulations, or as a European Work Council rep. Refusing to work on a Sunday if the employer is a shop or betting office. Asserting rights under the Agency Workers Regulations of 2010. Asserting rights under the Tax Credit Act of 2002. Being a trustee of a pension scheme. Being absent on jury service. A reason relating to pension auto-enrolment. We're now going to move on and look at notice pay. As well as redundancy pay, employees being made redundant are entitled to full statutory notice, or their contractual entitlement to notice, whichever is the longer. The notice period is 1 week if their service is between 1 month and 2 years, or 1 week for each year if they have between 2 and 12 years of service, up to a maximum of 12 weeks. An employer who does not want an employee to work their notice must make a payment in lieu of the notice entitlement, often referred to as payment in lieu of notice. Notice pay should include the value of any contractual benefits the employee would have earned had they been employed during the notice period. Let's look at redundancy pay. The UK has a statutory redundancy pay scheme under Section 135 of the Employment Relations Act 1996, an employee who is redundant and has worked continuously for the same or an associated employer for at least 2 years, regardless of the number of hours worked in a week, has the right to statutory redundancy pay unless the employee accepts suitable alternative employment, or the employee unreasonably refuses suitable alternative employment, or the employee was dismissed for gross misconduct, or the employee terminates his or her contract during the notice period, or the employee refuses to extend the notice period as a result of strike action. So, who isn't entitled to redundancy pay? The following categories of workers have no right to statutory redundancy pay. Employees with less than 2 years continuous employment. Self-employed workers. Individuals without a contract of employment. Civil servants and other public employees who are covered by their own agreement. Foreign government employees. Seafaring workers who are covered under different agreements. Domestic workers employed by close relatives. And employees married to their employer. Calculating redundancy pay. Statutory redundancy pay is calculated using a statutory formula based on an employee's age and length of employment, multiplied by a week's pay. The formula for entitlement is, up to the age of 21, a half week's pay for each year of service. 22 to 40, a week's pay for each year of service. Age 41 and above, 1.5 weeks pay for each year of service. The maximum number of years of employment which can be taken into account is 20. There is an online ready reckoner to calculate redundancy pay on the gov.uk website. Simply use your search engine to find this. So what constitutes a week's pay? Under the statutory scheme, the level of redundancy pay depends on an employee's gross earnings at the date of dismissal, but the calculation of a week's pay is subject to a statutory cap and is revised each year by government. From the 6th of April 2020, the cap is £538 per week, or £560 if you're in Northern Ireland. Anyone earning less than £538 per week receives statutory redundancy pay based on actual gross earnings. Redundancy pay is based on earnings at the dismissal date, so an employee who has previously worked full-time but is working part-time at the dismissal date will have the whole of their redundancy calculated at the part-time rate, with no reference to their previous full-time work. You should also get a written statement. Under Section 165 of the Employment Relations Act 1996, the employer must give the employee a written statement explaining how redundancy pay has been calculated. So, is your redundancy payment taxed? The simple answer is redundancy pay is tax-free up to £30,000. Above this level, income tax is payable at your usual rates, depending on an individual's income throughout the year. Pension lump sum payments are taxed separately under different statutory arrangements. Tax will be paid in the normal way on payment in lieu of notice, holiday pay and arrears of pay for work done. So are you entitled to benefits? Employees who become unemployed through redundancy are usually entitled to job seekers allowance and may be entitled to universal credits. The fact that a person has received a redundancy payment is not a bar to receiving job seekers allowance, but if the redundancy package includes pay in lieu of notice, there is usually no right to job seekers allowance until the notice period has expired. Time off to look for work. Employees with at least 2 years of continuous employment and who are under notice of redundancy have specific rights to reasonable time off to look for a new job, attend interviews or arrange training. The time off must be agreed by the employer, and employees are entitled to be paid as normal for the time they take off. Let's look at alternative employment. As part of the redundancy consultation process, employers have a duty to consider whether employees likely to be affected by redundancies can be offered suitable alternative work. To comply with Section 141 of the Employment Relations Act, an employer must make an offer of alternative employment after notice of termination is given, but before the employee's existing contract comes to an end. In addition, the start date for the new job must be immediately after the termination of the old job, or at least within 4 weeks. So can you turn down alternative employment? If a person turns down an offer of alternative employment, their entitlement to redundancy payments depends on whether the refusal was reasonable. The new job must be suitable alternative work. The terms and conditions of employment must be broadly comparable, and the skills and experience required must be within the employee's capability. The following are some of the factors that need to be considered: changes in pay, changes in working hours or working time, the change in the status or grade of the employee, changes in the way work is carried out, changes in work location, and employees' individual circumstances, such as domestic arrangements, caring responsibilities, travel difficulties, and their state of health. Finally, we're going to look at trial periods. Employees under redundancy notice who are offered and accept alternative work are allowed a trial period of up to 4 weeks. During this time, they can decide whether the new job is suitable. Entitlement to a trial period is guaranteed whether or not an employer agrees. Even if no trial period is offered, the first 4 weeks in the new job will count as a trial, entitling the employee to leave and claim a redundancy payment during or at the end of the 4-week period. If a person works beyond the 4-week period, they lose their entitlement to a statutory redundancy payment. It is important to know that the trial period is counted in calendar weeks rather than working weeks. This means that periods of closure or company holidays will count towards the trial period. An agreement for an extension in the trial period should be in writing and be made prior to the commencement of the new contract. I hope you found this presentation useful. You can find more help and support at www.learnwithunite.org. We have a REX resource bank with additional materials covering redundancy. We also have the Members Matter Redundancy Support Area. It's simple and free to join and open to all our members. Here you will find access to information and support available in your region. It will also introduce you to your Learn with Unite team, who can help and assist in redundancies in your workplace. We'll see you soon at learnwithunite.org.